Mr. Hewitt, if it speeds you on your way, we don't need to hear you on the argument that a line can be drawn between tax avoidance and tax mitigation.
Thank you. That will save some time. I was going to start with section 740, which we haven't formally looked at yet, although we've discussed it. It's on page 1041. So there has to be, to begin with, a transfer of assets, either alone or with associated operations. And income must, as a result, become payable to a person resident outside the United Kingdom. So that's the first condition. And an individual ordinarily resident, so again there's a residence requirement in the UK, and this one must be one who is not liable to tax under section 739 by reference to the transfer. They receive a benefit provided out of assets which are available for the purpose by virtue or in consequence of the transfer or any associated operations. So that doesn't, answering what Lady Rose saying, that doesn't have to have any, we're going to come on to see what the income is in a minute, but that doesn't have to, the benefit doesn't have to come out of the income. It just has to come out of the assets which are available for the purpose by virtue or in consequence of the transfer. So it could be a capital payment, and of course benefit is very wide. It can include the provision of interest-free loans or occupation of property or other benefits which have to be valued then. So that's the benefits. The benefit would then be valued. Then you look at subsection 2. Subject to the provision of this section, the amount or value of any such benefit I mentioned in subsection 1, that's the valuation of the benefit, if not otherwise chargeable to income tax. So sometimes the benefit might be a payment of income by the non-resident structure, which would be chargeable anyway. So that's taken out. Shall be shall, to the extent it falls within the amount of relevant income of the years of assessment up to and including the year of assessment which the benefits receive, be treated for all the purposes of Income Tax Acts as the income of the individual. And then to the extent it's not treated as his income for that year, then it transfers, carries forward to the next year.
Just ask.
So for instance, you can receive a benefit. What I mean by that, what that means is the relevant income can arise before the benefit or vice versa. Sorry.
So I just wanted to ask, do we get anything from the title of the section, liability of non-transferors? And might it be said that this is Parliament, in effect, accepting the decision of the House of Lords Majesty, which had said that liability under section 739 was a liability of transferors?
It certainly enacted it. One has to accept it enacted it on the basis of what was said in Majesty. I mean, this comes from 1981, which was when it was introduced.
This is precisely
in the aftermath of Majesty.
Yes.
Yeah. Yes.
Right. Thank you.
If it was not by way of income, or it was a free loan or occupation of a property, how does subsection 2 work then? Does it have to be valued and then the value is treated as income, or is it?
No, you treat, there are two things you have to look at. One is the relevant income pool, as we call it, which is the amount of relevant income generated.
For the person abroad?
Abroad, yes. The income that arises to the person abroad, that's the relevant income.
Yes.
There will be a pool of that, an amount, 100,000, 200,000, 300,000.
Yeah.
And then there is a separate matter to look at, which is the benefit provided out of the assets to the resident beneficiary, let's say, of a trust or something like that.
Yeah.
And you match those arithmetically, mathematically. There's no physical connection between them necessarily. So if the amount of relevant income is 100,000 for the year, and the person receives a benefit of 150,000, what valued at 150,000, they will be charged on 100,000 for that year.
But suppose this was the provision that had been applied to the fishers. and suppose that the profits of SJG were £1 million in a particular year, at the moment, because you say they come within 739, they're all taxed on their shareholder proportion of that £1 million as if it was their income.
Yes.
But how would it be different then if they, and that's whether or not they've actually received any income, it's just their power to enjoy it that leads to that result. So how would this work if there was still SJG, it still made £1 million profit, suppose that actually nothing was paid to them here, paid to Anne or Stephen here, would they then...
There'd be no charge.
There'd be no charge. Or if they get £10,000 salary paid to them here, well, that would be their income anyway.
That'd be charged to income tax.
But if somehow they get some benefit of £10,000, I don't know, if they go out to Gibraltar and live a high old time, then...
Paid for by the company.
Paid for by the company, then...
They'd be taxed on the value of that.
They'd be taxed on the value of that.
Yes.
Right.
Assuming they're not within 739. This is
Yes, that's what I'm assuming for the moment. I see.
That's right. But the way this works is it charges you on all of the relevant income. Now, if there are two persons who receive benefits in the same year, let's say, on the face of it, they would both be charged on the whole of the relevant income, but that's when Section 744 comes in, and there would then be an apportionment of the relevant income between the beneficiaries who received a benefit. Because the same income cannot be charged twice under 744, and if there's a choice, which there would be if there were two beneficiaries who received a benefit, then you would apportion it between them. So I think my example was that an example might be there's £100,000 of income. There are two beneficiaries who both receive £100,000 each of benefit in the year. There's only
such as what? They both go out and stay in a house or something.
Well, they might receive cash, £100,000 appointed to them from the settlement. There's lots of ways that they can get a benefit. They might be given an interest-free loan of £1 million. This is pretty...
Under Section
So the amount of profit, the amount of income received by the person overseas operates as a cap, effectively, on the amount that can be brought into tax for all the people caught by both 739 and 740, or just 740?
Yes, it would apply to cap both. Yes, the same income cannot be charged twice under 740 or under 739 and 740.
Why do you need an apportionment if you're a Section 740 taxpayer? Because you're taxed only on the benefit that you receive.
Yes, but you're also only taxed. There's only I'll give you my example. There's £100,000 of relevant income in the year in total. Two beneficiaries both receive £100,000 benefit. You wouldn't expect them both to be charged on £100,000. Because there is only £100,000
yes, so it operates as a cap.
So you have to apportion the income, the relevant income of £100,000 between the two beneficiaries. 50,000 each would be the obvious way to do it.
Oh, I see, that's how it works. Okay.
Maybe if you look at subsection 3, that makes it clearer. Because the relevant income in relation to an individual is the income which is available effectively which could be used for providing a benefit for the individual.
Yes, could be used.
You couldn't simultaneously have the same money available to provide a benefit. If there's only £100,000 of income, it can't provide £100,000 to two individuals.
It can't, but the benefit, this is why I'm making the point, the benefit is not coming out of the income. The benefit is just coming out of the capital, perhaps.
Yes.
So that's right. That's a definition of relevant income. It has to be available to benefit. It doesn't have to actually benefit the person. It has to be available to benefit them, as long as it's relevant income in relation to them.
If you've only got X, then there isn't 2x available to benefit people.
Exactly, yes. Yeah.
But actually 2x may come into the country as a benefit if, as you say, it comes from capital or comes from accumulated income from previous years.
Yes, exactly. Oh yes, it's quite common for it to mismatch quite considerably. But of course that carries forward in a sense, because if relevant income arose in a later year, you could still be charged. You would match it up with the benefits you got in the previous year and you'd be charged. So it doesn't matter what order the things happen in. You end up being caught eventually if on the relevant income actually arises matching with the benefits. The point I was making about this was that it doesn't solve the problems that the Fisher's construction of Section 739. If you remember, the example that we were talking about was an individual who controlled the company, could have a 51% shareholding, could have a 60% shareholding, but it doesn't really matter. They control the company. There's a transfer procured by them and the minority shareholder. But the Fishers say, well, the minority shareholder is ignored. It's only the controlling shareholder who is the transferor. He will be taxed on the entire income of the non-resident under 739 because he is the only transferor. All of the income is charged on him. If a couple of years later a benefit is provided to the minority shareholder, let's say, from the assets, and there's no further income arising, they won't be charged under 740 because there is no income to charge them. It's been charged.
That, to coin one of your phrases, is a rather unrealistic scenario. But I think it is right that if in the same year, from the £1 million that SJG makes in profit, one person is caught by 739 because they're the transferor, but a non-transferor also gets a benefit in that same year, then I think there would be apportionment between.
There would be, exactly.
Yes.
Lady. But my point simply was you can't say simply, sweepingly, that 740 will solve the problem.
No, it doesn't solve
the situation, the unfairness of the majority shareholder bearing all the income, whereas the minority shareholder, of course, will, in the non-resident company, will have a significant interest.
And the problem for the
40% shareholding in the non-resident company.
The problem for the non-resident, for the majority controlling shareholder under 739 in the first year is that 740 only operates where there's a choice between who is going to.
Exactly.
But that's a glitch in the legislation in a way.
I'm not sure it's a glitch. It is a structure of the legislation because each year has to be dealt with on its own, and then you don't carry that forward.
But it's a glitch in the sense that on your wording you get landed with tax for the whole of the income accruing to the overseas person, even if you've only got a 51% share.
It's not. That's on the Fisher's case, yes.
Yes.
On our case, it would be shared between the majority and the minority shareholders in proportion.
Yes.
So there wouldn't be no unfairness.
Regardless as to whether they received it.
Regardless of whether they received it, exactly, because they're within 739, exactly.
740.
They've got power to enjoy the income.
740 is proceeding on the simple basis that if you actually receive a benefit, you get taxed on it. And that was Parliament's response to Majesty.
Yeah, but that is subject to 739. Yeah. It's always subject to Section 739. It's intending to cover the situation that isn't covered by Section 739. So I don't think that answers the question, the point I'm raising. My point simply is the Fisher's case, which logically it has to be that case, produces arbitrary and completely absurd consequences in relation to majority shareholders.
It could be said that the idea, the Fishers in this case would not have been taxed at all if these companies had been within the United Kingdom.
They would have been not on the income of the company. That's quite correct. Yeah. But that would be the case with the majority shareholder in the Fisher's example. I mean, either if you want to say that in no case where an individual procures a company to transfer assets that 739 applies, well, that's one thing. But that really does shoot a massive gap in 739, and in every case since Congreve has recognised that is necessary to cover situations beyond direct transfers of property which you own to situations where you procure transfers. I mean, there are other kinds of situations that you have to bear in mind. I mean, for instance, property might be held by a partnership. It might be transferred abroad. It might be held by an LLP. It could be held by all sorts of different entities.
Well, but they will be taxed on the profits of the partnership as income tax anyway, won't they?
The profits of the partnership, I'm talking about the partnership having partnership property, which is then the partners procure to be transferred abroad. Or an LLP. All I'm saying is there are lots of different situations, apart from companies. But if you simply limit 739 to a situation where a transferor owns beneficially an asset and then transfers it directly, then, well, 739 becomes completely O2s, really.
But standing 746, is it open to this court to take such, standing section 746, is it open to this court to take such a narrow view of section 739?
I'm not sure what you mean by 746, but
it's getting back to the point. I think we 747. I think 747 4B.
Oh yes.
If you look at it, Parliament is clearly working on the assumption that the transfer can be made by a company.
Yeah, I think that's right. Yes.
Yeah. So it's not really open to this court to say this is just transfers by individuals.
No, and also there's a line of authority, which
quite apart from that, yes.
Majesty and Pratt, etc., which all recognise this.
Yes, I mean, clearly the court
sense.
Theoretically could depart from a line of authority, but
yes.
Parliament has recognised that the charge applies to a company.
Yes.
Yes.
But it's not just that, say, my lord. It's the fact that, well, first of all, you are reading in this into the section. As I pointed out before, there aren't any statutory words that you're construing to limit the effect of section 739. It doesn't say it only applies to a transferor, in which case there would be an argument what was meant by a transferor in section 739. None of that appears. What the court is doing is limiting it, and so you would be saying this broad anti-avoidance provision is only going to apply in very narrow circumstances where the individual transfers their assets. Now, once you accept, I submit, once you accept that it can cover cases where shareholders, whatever, procure the transfer of assets, then inevitably the next step is a very small one to say that must cover situations where more than one shareholder is jointly procuring a transfer. Because again, that just pushes the problem further on.
I'd say, with respect, I didn't understand the point that you, I believe, adopted in relation to section 747. And clearly, an individual could have an asset in the form of shares and could transfer that to someone overseas. And you could then get into the regime of companies holding shares under the section 747 CFC regime, where a United Kingdom company has to recognise as its own income of a company located abroad. And I rather read the subject to section 747, which we don't have in the bundle, but having done the best I could to look at it overnight, and I might have got it wrong, but I rather understood that to operate on the basis that if you have income under the CFC regime, which is treated as the income of a parent company in the UK, then we'll take that income out of the section 739 regime.
The income of the subsidiary or the foreign subsidiary, that's right.
And we won't tax the individual under section 739 because it's going to be taxed under the CFC regime. But if that's right, that doesn't seem to me, subject to being educated further, to say anything very much about the interpretation of section 739.
The example you've given, my lord, wouldn't engage section 739 in relation to the income of the subsidiary. If I own shares in a company and I transfer them to another UK, I own shares in a non-resident company, I suppose you're saying, and I transfer those shares to a UK company, that wouldn't bring...
But the CFC regime works, I think, not on wholly owned subsidiaries, but subsidiaries owned, I can't
Control.
remember,
I think it has to be control.
the control. So you could have individual owning shares in a foreign subsidiary, transferring those shares to someone outside the jurisdiction, where there's also sitting in the background a UK company with control of that
Other company.
other
Yes.
company,
Okay.
where the income of that other company is attributed and treated as income of the UK parent company with control. And anyway, that's how I understood
You have to assume
Section 747
You
to
have to
apply.
also assume that the individual also has power to enjoy the income of the company it's
Well, they
transferred.
would do it if it declares a dividend or.
No, because you've just transferred it. After the transfer, I mean,
Well, I think material words in 747B begins, if apart from this paragraph, then comes material words, section 739 would deem any sum forming part of the company's chargeable profits for that accounting period to be the income of an individual for the purposes of the Income Tax Act. So it's envisaging that under section 739, a company's chargeable profits are deemed to be income of an individual.
That's the point I was making, that the individual can start off owning shares, which are assets, transfer those to someone in circumstances where that transfer is caught by Section 739 and therefore would be deemed, if they have power to enjoy the income of that.
they'd have to have that as well, yes, exactly, yes.
But if they have, then it would be, under Section 739, would be deemed to be their income. And I was rather reading this provision as saying, if in that sort of situation where, in theory, you can attribute that income of the underlying company to the individual shareholder in the UK, and would, subject to this provision under Section 739, do that, nonetheless, if that subsidiary company and its income is caught by the CFC regime, we won't do that. We'll treat it all as within the CFC regime.
Yes.
Is that the way that it works?
Well, it could. It says work. I mean, I think that sounds theoretically as it could.
All right.
Could
I mean,
yeah.
I had to print this off overnight. You haven't based any argument upon specifically upon Section 747, but that seemed to me to be the way it worked. But if that's right, that's why I was a bit confused. It didn't seem to me that Section 747(4)(b) actually gave much of a clue as to how to interpret Section 739.
Well, I think.
Have I misunderstood that?
I'm
asking for help.
What I was relying on 747(4)(b)(4) when I was referring to it yesterday was for the fact that in situations where you've got large companies, which are the examples that have been given, and they create subsidiaries and transfer assets to them, which would be the typical situation that you would have with a large public company, that would be charged under 747. Most likely, and not 739.
Yeah, I mean, that would be one example of where you've got a structure created that falls within the CFC regime, therefore the income is caught and attributed to the UK parent company under that regime. This provision seems to be saying, well, if that's happened, you take it outside Section 7.
But that is the very kind of example that has been given, particularly by Lord Justice Phillips, as to why the multiple transferors cannot be right at all. He says they can't be right because, look, if you have a public company, then lots of shareholders, and they carry out a transaction like we did in the Fishers case, then they might all be caught by it. And my point is, well, one, they wouldn't carry out a transaction like the Fishers because that would just be completely unrealistic for them to create a new company, have 1,000 shareholders, become shareholders of it, and then transfer assets to it. What they would actually do is transfer assets into group to a subsidiary which is non-resident in order to, if they were trying to avoid tax in some way. And that would all be within the corporate regime, within the CFC regime. That was what I was pointing out. So what I'm pointing out is 739 will not apply in general to actions by public companies in creating foreign subsidiaries and transferring assets to them.
But is that because, and correct me if I'm wrong, 739 subsection 1 the second line, the avoiding by individuals ordinarily resident in the United Kingdom of liability to income tax must be a natural individual.
Well, no, it's because
Well, does it have to be a natural individual? Does that individual has to be a natural?
because it begins by saying subject to section 7474B, which is the provision which my Lord has read out, which in the CFC code says if the profits are of the foreign subsidiary are attributed to the UK parent or controlling company under 747, then it cannot be charged under 739.
But I think one always needs to remember that the CFC regime is based on control, not total ownership. So that does leave open the possibility that a UK company and a subsidiary, controlled subsidiary overseas, fall within the CFC regime, even though there are shareholders in the UK company or indeed in the overseas subsidiary who hold shares in it. They just happen not to be the controllers.
Yes, no, sure.
And
the profits are not attributed to them, they're attributed to, well, sorry, they are attributed to them in theory.
yes,
It's all attributed by pro rata, but it's
Yes.
the company, the UK company, that gets charged the corporation tax.
yeah.
So if I own some of the shares and the PLC owned the rest, they would be charged on the pro rata amount.
But because the CFC regime works on the basis of control, that in itself might be a fluctuating picture, whether the UK resident company happens to own enough shares to satisfy the inception of the CFC regime or not.
Well, that's true, but I mean, we're...
Okay.
We are,
Anyway,
yeah.
sorry, I just wanted to
yeah.
explore how far Section 747...
Well, correct me if I'm wrong. I thought that the individuals in subsection 1 were natural individuals. Whereas
Yes, individuals, yes, yeah.
They are.
Yes, it must be, because they have
They
to
must
be
be,
liable to income
Indeed.
tax.
Yeah.
Yes,
And the contrast is with the word persons in the last line.
Well, which can be include a company. Yeah.
Right.
Yes.
But I thought you were relying on 747 to say it must be the case that the transferor, the main transferor under 739, can be a company. And therefore, because a company is not an individual, this must be envisaging that individuals can also be transferors when the transfer is made by a company.
it envisages that it can be a company. It doesn't have to be a company, as my Lord Sales. There are situations you can envisage
But
when
looking at
But it can be.
747B, wouldn't that apply if an individual was the actual transferor, was the owner of the asset, and transferred that to an overseas company?
It could, yes, yeah.
So,
It could also apply where the company, the UK company, transferred the
well, yes, but the existence of 7474B doesn't necessarily prove that a transferor for 739 purposes can be a company.
I think that, yes. I don't think I'm suggesting it can prove it absolutely, but it is, well.
But also, I mean, it doesn't enable you to escape from the words "such an individual" in subsection 2, which is the charging provision, does it? Doesn't that make it clear that, for the purposes of the charge in section 7392, it has to be an individual, it's not a company?
Well, no, because I think such an individual is referring there. If you read on, that's talking. Such an individual has power to enjoy.
Okay.
So that's talking about the individual having power to enjoy the forthwith or the income of the person resident or domiciled.
Right. Okay.
It's not talking about the trans. That's the problem with the. That's why we had a difference of opinion between Congreve and Majesty, because there isn't anything that actually identifies anything about the transferor or whether there needs to be a transferor. I mean, the House of Lords and Congreve were not stupid. They were interpreting these words. They weren't taking account of the fact that there wasn't this apportionment provision because they didn't have a case where there was more than one person involved. So they hadn't taken that into account. Nobody drew it to their attention. But just looking at the words, their decision was perfectly rational. Because there is absolutely nothing which limits the scope of the provision apart from the fact that the individual who is resident in the UK has to have power to enjoy the income of the non-resident. And there has to be a transfer of assets. So there's a transfer of assets. As a result of that, an individual has power to enjoy. That's why in Congress, the House of Lords simply read that as it stood to say, well, it doesn't matter who made the transfer. Now, we now after, well, Majesty said it doesn't matter because of the, well, we know why. And we're now grappling with, if it does matter, how do you delineate the scope of who the transferor must be, can be?
Yeah.
That's what this is about. And the question is, how narrow do you go? Do you say the transferor has to be someone who actually transfers assets outright, or do you include someone who has procured the transfer by another entity, such as a company or a partnership or a whatever, or and do you include?
Well, the question is, does the transferor have to own the asset that's transferred?
No.
Well, that's the first question. Do they have to own the asset? But the second question is, if you accept they don't, can it be enough? Is it limited to one person? Which I think is the Fisher's primary case, that it has to be one individual who can control the company and procure it, and that's the limit of it. And as soon as you have two individuals, so for instance a deadlock company, which is our example, as soon as you have a deadlock company, this doesn't apply, and 739 is completely out the window. No matter how much tax avoidance is going on, it's completely irrelevant if they're right. You can be avoiding endless amounts of income tax or any tax, but it wouldn't matter. So what they say is there's a bright line there between a single individual procuring and more than one individual having the ability to procure jointly. And we say that's a wholly irrational distinction, and produces a situation, a distinction between somebody having a 51% holding in a company and procuring it, and two individuals, say brothers, I think was an example, having 50% with nothing that splits the deadlock. So they have to act together. So if the Fishers are right, the brothers can transfer their assets wherever, procure the transfer wherever they like. Nothing, 739 will not apply to them.
And 740 would apply.
740 will apply if benefits are paid out while they're resident in the UK.
And in a year in which there's income generated to the person.
Well, after or before, because it carries forward, etc. But the problem is, of course, what happens is people roll up the income and then perhaps go non-resident, or they can extract it by some other means. So there is a big difference between a charge on the 739 and a charge on the 740. Very big difference. Well,
Yes.
I hope the one point I wanted to make was about joint owners. Because it's in our submission, there is a situation where clearly there is a joint transfer by individuals who own assets. So you might have joint ownership of chattels, for instance. I think a painting was a common example. Two people own a painting jointly. That would be the transferors. They would both be a transferor if they transferred the painting by agreement. They agreed to transfer it and transfer the painting to a non-resident. There would be a single transfer of assets in our submission, but by more than one transferor. And that's a case where undoubtedly Section 739 must apply on any view. Now, I think my learned friend's answer to this was, well, actually they're transferring their beneficial interests, so there's more than one. But that simply is not correct. It's not consistent with Section 739. The asset that's transferred in that case would be the painting. Any income that arose would be arising from the painting. So, for instance, if it was leased, which is something that does happen, leased to an individual who wanted to have the painting on their walls, income would arise from the painting. And the answer to that is, we would submit quite simple, that there are two transferors and there is an apportionment of the income between each of the transferors in proportion to their interests, probably, and power to enjoy the income of the non-resident would be the most obvious way, but on a just and reasonable basis. There aren't two transfers of two different assets.
And how do you say before Section 744 was enacted, Section 739 would have applied?
Very good point. I'm not sure. I think it probably was based on the Majesty approach, I imagine.
Which means what?
Which was the revenue doing a extra statutory.
Right, so we know that was not permissible, so how do you say in principle it should
I think there was
be dealt
simply I think before then there was simply a lacuna. They didn't. There was nothing in the statute that dealt with it.
Well, why aren't they both caught? So the
Well, they
income
would.
is
Well,
attributed to
I
both.
suppose that would be the answer. That's where the revenue's dispensing power, because there is an overriding principle of non-double taxation. So you would expect that to somehow come out. But I don't think there was anything statutorily that allowed it.
All right, thank you.
I mean, it's a different situation because, of course, in the Majesty kind of case, the revenue were relying on their dispensing power to justify a charge. In a case like this, it would be being relied on to remove a charge because if the legislation on its face imposed a double charge. But I agree there would have been a problem before 1981. But that's not, with respect, it's not necessarily relevant to construing the current legislation.
Yes, your point is that we look at the legislation as it now is, across the board. You're saying this is Farrell and Alexander.
Don't look at the archaeology and try and deduce something from that.
Yes.
That's right. No. But we say that supports the view, strongly supports the view that there can be multiple transferors and then an apportionment under 744. Sorry, I may have to press on, but I'm happy to answer.
Yes, don't apologise. I realise
Any questions?
you've still got some distance to go.
I understand this is very important, and certainly to those of us in tax, and I understand you obviously want to get it right.
It'll be the fourth attempt by the highest court. It'll be the fourth attempt at these provisions by the highest court.
Yes, and the best, I'm sure.
I'm so sorry, and I appreciate that you have got to press on, but just on that Farrell and Alexander point, you told us yesterday, I think, that where you have a decision on a previous version of the consolidated legislation, that ordinarily that would continue to be treated as authoritative for interpretation of the subsequent
It's the same.
So your point, as I understand it then, is that that Section 744 and or subsection 1A have been introduced into the scheme since the Majesty interpretation of the previous consolidating legislation. So in 1988, we're in effect starting with a fresh slate so far as the interpretation is concerned.
Yes.
Is that right?
I think that's right, because because these changes have undermined the rationale.
That bit I understand.
You use the phrase, it's a code, and I think the code of these set of provisions you say is different, and the fact that some of the wording may actually have been cut and pasted doesn't affect Farrell and Alexander because the code as a whole has changed, and that has to be now looked at.
Exactly. Yes. 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 Can I then turn to the problems which, very briefly, the problems which the Fishers raise with this approach? And I'm going to try and deal with this very quickly, so hopefully... first is the problem with the motive defence. And I hope I've explained why, you've seen from our case why, paragraph 38 particularly, why there isn't a problem with the motive defence if there's more than one transferor. The basic point is it's the purpose of the transfer you're looking for, and that's a matter that has to be looked at in many contexts in tax by weighing up the views of various individuals, natural persons, in particular where the purpose is the purpose of a company. You have to also recognise that the purpose provision of the motive defence applies to associated operations. And those can be affected by companies, there's no doubt about that. So an associated operation could be affected by the non-resident company that the property was transferred to subsequently, or another company in the group if the assets were moved about. And in that case, we're not looking at the views of the transferor or the individual. We're looking at the purpose of the transfer, looking at the views of those who are controlling the company at the time. I think I mentioned the Court of Appeal Brebner, which is a famous, rather overrated case, I feel. Was also an example of that, because in Brebner, the objects that you had to look at were the objects of a number of companies, in fact. The commissioners in that case had to weigh up the objects of all those companies and the directors to decide. So there isn't any problem, we would submit, with the motive defence, and also the fact that there are joint transferors, in my example. The motive defence would have to be applied. You also must remember the motive defence applies to section 740. It's the same motive defence, same transfer. So it would apply to either. So it can't apply differently in relation to different transferors, because there has to be a single answer to the motive defence in relation subsequently to a 740 charge. If the motive defence applies, 740 doesn't apply either. So it's not just focusing on the transferor. Scope for double taxation is the second point.
Sorry, just on that.
Yeah.
Since section 741, the motive defence is a defence for an individual, wouldn't it be possible for one individual to succeed in making out the defence where another did not?
Well, it's the same. It would be the same. It's the purpose of the transfer.
Yeah. So for example, if you were a shareholder who was opposed to the transfer, your answer to the assessment is that you were not a transferor. It's not that
No.
it's not that you didn't have the necessary motive.
Yes.
Because it's not your motive. It's the purpose of the transfer.
Yes. And equally, it would be the purpose of the associated operation subsequently, which the individual who's being charged might have nothing to do with at all.
So that's why if Anne did not have could not rely on the motive defence if she was a transferor, even though there was a factual finding that she had no motive herself.
Herself, yes, but there was a motive for the transfer. There was a purpose to the transfer,
So it either applies to everybody or nobody.
Exactly. Carville was an odd case where the same transfer was litigated in 2 different years before the commissioners and different results were obtained.
Let's not make it more complex.
That's a different point. They simply came to a different conclusion on the facts in different years, but it was the same transfer and the same question. But oddly, different courts. There's a principal income tax that each year is dealt with separately. There's no issue of estoppel between years. So you can litigate the same point over and over again if you want. Scope for double taxation, we've dealt with that. It's we would say section 740. It's not an answer to that to ask what problem it was enacted to resolve. In any way, that's pure speculation. It deals, which is what the Fishers say. The Fishers say, well, it doesn't apply because it wasn't enacted to deal with this particular problem. But that's not the question. The question is, does it apply to solve this particular problem? And it deals with double charges under section 740, 744. So why does it not deal with double charges under section 739? It isn't only designed to deal with the overlap between 739 and 740. It's designed to deal with potential double charges, as I've already explained, under section 740 as well as section 739. So there's nothing in the wording that limits it. And this isn't a question of extending the scope. It's a question of the correct construction of the legislation now that it contains that provision. Equally, before the 1988 Act, you would have construed the 1970 Act with the amendment, which is what I showed you in Benyon, the amendment in 1981. And the third one is problems with minority shareholders. I think we've possibly dealt with that point to some extent. So unless you've got any further points, could I just move quickly to the motive defence? And there are 4 points, but I'm not going to deal with one of them, as your Lordship indicated. The first is the construction of taxation in section 741. And the first point to make is the point which my Lord Sales made, which is a linguistic point. And it's particularly stark when you look at 1936, because you have...
But I thought we don't look at 1936.
Well,
under Farrell.
we're looking at 1936 because Sassoon, which is the case that was actually a decision on the 1936 provision, in fact. But all the 1936 does is show it because it's placed together. It doesn't actually matter in principle. There's an emphasis, really. We still have the contrast between section 739, which talks about income tax, which is the equivalent of subsection 1 in 1936, and 741, which talks about taxation. And we say there's an important significance in the fact that they talk about taxation. And that's why I would submit in Sassoon, the court was so dismissive of the taxpayer's argument. They didn't even ask the...
They didn't call on the...
They didn't call on the
Solicitor General.
Attorney General, which bizarrely, the Fishers rely on as a point against the case. If every case where the court thought it was so obvious that they didn't call on the respondent had less authority than other cases, it would be a very strange day. I mean, if you read the decision...
The argument against you is that the approach to the interpretation of legislation generally, but specifically tax legislation, since Ramsey has changed since the time when Sassoon was decided.
Yes, and the question is are the relevant statutory provisions construed purposefully intended to apply to the transaction in question, viewed realistically? That's Barclays Mercantile, UBS, and cases like that. And that's a very different analysis from the analysis that was conducted in Sassoon, which was a literal interpretation with precious little reasoning.
Well, it was literal in the sense that it was looking at the words that were used, which I would submit to my Lord, as you said in the old case, is a starting point, an important starting point.
Oh, of course
the
it
words
is.
used were, and the contrast between the use of income tax and...
Yeah, but the effect of it, as I understand it, and correct me if I'm wrong, is that if the 741 defence covers all taxation, then the description of the 739 charge as being for the purpose of preventing the avoiding of income tax is a misnomer.
No,
it's a prevention of avoiding of tax.
Well, I wouldn't agree with that, but I would agree it's not a complete statement of the
But
purpose.
it's a statement of the scope of
It's
the
important.
charge.
It's definitely an important part of it. You do have to also remember the context of when the provision was introduced. The income tax was the main tax. Many of the taxes that we have now didn't exist then, including corporation tax.
But it was used in Sassoon in respect of estate duty.
Exactly, yeah. No, there were other taxes, undoubtedly. And of course there were surtaxes, which were a form of income tax, but weren't actually income tax. So I suppose you might have said, if you're trying to avoid surtax, you're not within the provision, but that would be a pretty bizarre conclusion. You have to remember, betting duty is a tax on income. It's gross income, but it is on the bets that the bookmaker receives, which is the bookmaker's income. So it is a form of taxation on income.
It's not. Are you arguing that it's income tax within the meaning of 739?
I'm not suggesting that, but I'm just saying it is a tax on income. It's not a tax. It's not a tax on capital like estate duty. So it's actually even closer, one would say, to income tax in that way. So I would say that was what drove the court in Sassoon to the conclusion that it was obvious that taxation meant taxation and didn't mean income tax. I've already made submissions on subsection 1A, and I think the only other thing I have to show you is in this respect the Income Tax Act 2007, which does govern one of the years, and it is the legislation that carries on being enforced. So it is important that we get that right. The legislation is in 1909. So Section 737 is the legislation that now applies to post-December 2005 transactions, and 739 is the legislation that applies to pre-December 2005 transactions. And in a situation where there are both post and pre, so for instance if the transfer was pre-2005, but there were associated operations occurring after 2005, you have to apply 739 to the transfer and 737 to the associated operations which occur after the date. And I think, as has been pointed out, in 737 there is a definition of taxation as including any revenue for whose collection management the commissioners are responsible. That's at the very bottom, subsection 7 of 737. But that only applies to the post-2005 transactions. For the pre-2005 transactions, Parliament left the matter open.
What do you mean transaction?
Sorry?
What do you mean transaction?
Well, either a transfer or an associated operation.
But in this case...
They're all before. Yes,
but I thought you just said that one of the years of assessment has to be assessed under this legislation.
That's because the income arose in that year.
But I thought you said that if the transfer occurred before December 2005, then the old legislation applies.
No, the old motive defence provision applies, which is now section 739. To the income which arises out in 2007, the 2007 Act applies to it, but depending on when the transactions took place, the motive defence that applies is different.
Let me ask the question this way. If we were to be against you on Sassoon and say that actually taxation in 741 only refers to income tax, but that the situation has changed as a result of the widened definition of taxation in the new section 737, would that mean that the answer to the question of the Fisher's assessments would be different for 1 year from what it is for the other year?
No.
Why not?
Because...
is it because the transfer is...
all of the relevant transactions...
All of it comes from the original transfer, and that, in this case, and that transfer was before the 5th of December 2005.
Yes.
Yeah.
Okay. Exactly.
So in fact it would be a section 739 case under the new legislation?
Yes.
Right.
Exactly. But there will be cases...
And the reason for your answer to my lady was that subsection 1 of section 737.
Yes, but it depends what you mean by a transaction.
Well, there is another provision, sorry, which I haven't shown you, which slightly contradicts these, which says that, in effect, that if a transaction is before December 2005, you apply 739 to it. And if it is after, even if, so you could have a transfer before 2005, but a subsequent associated operation in relation to the same transfer after 2005, you'd have to apply the old provision, which is now 739, to the pre-2005 transfer. You'd have to apply the new provisions to the associated operation that occurred in 2009.
But in our case, all the relevant transactions are pre-4th December 2005. So the new section 737 doesn't affect the
That's
answer.
right.
Yeah.
That's right. but your decision is not of historic only interest, because there are plenty of structures in existence where the original transfer was pre-2005, but they're still going.
Yes.
Well, yes, if it hadn't been for the Fishers selling their shares, this one would be one.
Yeah. So it's still of great importance.
Yes, what you can say, based on 2007, is that you have the same definition of the charge in section 720, that it's designed to prevent the avoiding of liability for income tax, but you have a much broader definition, you have a clear, broad definition of revenue in the later section.
There is one thing, though, I'd like to show you, which is the explanatory notes to the 2007 Act, which are right at the very back. They're on page 3240 of the bundle.
3240.
3240. And these are the notes on section 739, which is the pre-2005 transactions.
This is HMRC's commentary on the.
No, these are the explanatory notes to the legislation.
Well,
Produced after the Act.
produced by.
That's
By
true.
the government after the Act.
There are explanatory notes on the bill, which I'm sorry we can provide, which are identical to this. So there's explanatory notes on the income tax bill, which was the official notes that are put before Parliament.
Well, they're not approved by Parliament.
They're not approved, but they are available.
Yeah, they're available to Parliament.
They're available. And they can be taken into account. There's no doubt.
So by lucky coincidence, section 739 of the 2007 Act is actually 739 of ICTA 1988.
741.
741. Oh, unlucky. Look.
Yes, it's very close. 739 of this Act was 741 of the ICTA. So, and what this says is, you'll see in 2184, this section continues to use the source legislation's word taxation, which has been the subject of case law. For example, Sassoon indicates that taxation in this context is not restricted to income tax. So we have a note, which is also the note to the bill, but we'll provide it to you, which seems to be indicating that Sassoon is...
So you would say
It's
that
indicating
you get there through the always speaking doctrine, basically, that we don't look at what taxation was in 1936 or whatever, or even 1988. You look at what taxation is at the time.
Yes, absolutely.
How does this assist you? Because this is a description of what Parliament understood in enacting the 2007 Act.
Well, I hesitate to intervene, but it's a statement, I think, of what the government understood when it introduced the bill.
The bill, yes, that is a better description.
It's whoever produces explanatory notes, yes. That's
Yes.
Yeah.
But that may be of some relevance in interpreting the 2007 Act, but is it relevant in interpreting the 1988 Act with which we're concerned?
I'm not suggesting... We're not. You're also concerned with the 2007 Act, actually, for one of the years.
For one of the years?
Yes, and also it will apply to future years. So it is important, not just for this case, but also for lots of other cases, how you interpret the 2007 Act. If you are going to interpret it differently, I hope you will not, but if you do, it will be very important, because this is the Act that applies now.
Yeah, we've just established that 737 doesn't apply to the facts of this case.
This is 739.
739.
Oh,
This is the note to 739.
Oh, I'm sorry, I'm with you, yeah.
That's why it's referring to Sassoon. It's talking about, because of course 737 has a definition of taxation, so you don't need to explain what it is.
Right. So they seem to have thought that they were carrying forward 741 from ICTA to continue to apply to pre-5th of December 2005 transfers.
Yes.
Whereas if Mr. Baker is right, actually they were modifying quite considerably the old 741 when reenacting it as 739 to apply to those earlier transfers.
If it's right that 741 didn't only apply to income tax, but 739 in the new Act applies more widely, then there would certainly be a significant change in the law. It's not surprising there was this note, because this is how everyone understood the provision at the time in 2007. I mean, I don't think anyone questions this, and it's only this case that it's been questioned. It's been the way that the provisions have been interpreted and applied for decades. All of us have been applying it in this way. We would be negligent if we hadn't. So it would be. I won't. You know, this doesn't make any difference, I know, to this court, but it would be a major change in the way that 739, 741 is applied. If you were to say it only applies to where the purpose is to avoid income tax.
But what is then the meaning of the opening words in 739 in describing the purpose of the charge?
Well, it is that there is a general purpose of preventing the avoiding of income tax. That's a general purpose of this quite severe provision.
Yeah, but you read it, I mean, effectively, the word income could be deleted.
It could, in a sense, yes. So it's designed both to avoid, to prevent income tax and other taxes. Yeah.
But this is an unusual provision where Parliament has chosen to define its purpose. I mean, normally we have to ascertain the purpose from looking at the legislation and analysing it in the round. In this case, Parliament has said, this is the purpose of this charge. And what you're really asking us to do is to airbrush out of the provision the word income.
Well, I don't think I'm necessarily doing that. I would suggest that the Parliament submit that Parliament was not exhaustively defining precise everything that the provision was designed to do.
Well, I understand your position.
Yes. Can I then deal briefly then, very briefly with, I don't want to, I have to be very brief, the purpose of avoiding liability to taxation. We simply say this is not an unusual type of situation, as my learned friend suggests. In many cases, a UK company, a UK business, would be competing against foreign competitors who've got much lower rates of tax. If they could say, we are entering into this tax avoidance transaction, not just to avoid tax, but also to allow our business to flourish or to save our business or whatever, because we're competing against people in other countries in our industry who have much lower levels of taxation, that would shoot a complete hole through the provision. You might go further, and an individual might say, I've got a daughter who needs an operation, and therefore that's why I avoided tax, because I needed the money to pay for that. I mean, once you start looking through the avoidance to the motive for the avoidance, there would be no end to the arguments. We would say that's simply a misconceived view. On the timing point taken by the Fishers, I'm not going to take you to it, but I'll give you the references. What happened, in fact, and this is something I don't think my learned friend told you, the branch was set up. Originally, it didn't take bets from UK punters because it had a undertaking to Customs and Excise not to do that. You'll find that in paragraphs 359 to 361 of the First Tier Tribunal decision and 385 to 6. They then changed their mind and decided that they were going to go back on that. SJG was incorporated in July 1999. From that time until at least November, Peter Fisher believed, wrongly, that the UK business had been transferred to SJG. He was mistaken, but he believed that it had been transferred. And we find that in paragraphs 62 to 69 and 465 to 470 in the first tier tribunal decision. In fact, before the first tier tribunal, the Fishers relied on this mistake as an argument in their favour. In November, he discovered, you'll find by reading the findings, he discovered it was held that it hadn't been transferred, but he still believed that if the transfer took place, it would be retrospectively treated as having taken place in July 1999. Finally, he was given advice by David Oliver that wouldn't happen, and after that, the transfer took place in February 2000. And it's that transfer, just to answer that question, it's a transfer of the telebetting business that we're relying on and that the first tier tribunal relied on to SJG. The point I'm simply making is we're looking at the purpose of the taxpayers here, their subjective purpose. And it was therefore relevant for the first tier tribunal to take into account the fact that they actually, although they hadn't transferred the business, they actually believed they had in July 1999. So it wasn't the case that they were intending to form the branch and trade from the branch and then subsequently make a transfer. They always intended that there would be a transfer. Simply, by mistake, it didn't happen. So we say there's nothing in the timing point that's being made. And finally, designed. Can we just to make absolutely clear what we say, before the first tier tribunal, it was agreed that Carville, in the special commissioner, was set out the law correctly, which was that the second limb, the requirement was that the main purpose of the transaction had to be to avoid tax. The main purpose. So it couldn't be a more favourable test for the taxpayer. That was the test that the taxpayer failed. The FTT decided, as a matter of fact, that the main purpose was to avoid tax. My learned friend now makes a point about design and says it has to have been designed that way in some strange sense. If you look at I hesitate to look at it, but look at the dictionary definition. And it's on page 3114 in the bundle. We would say 3144 here. This is the definition of designed in the Oxford English Dictionary. The first definition, as it always in the Oxford English, is obsolete or archaic. We say that the sense in which it's been used is plainly to, planned or intended. Not three, of a structure, work of art, product, system, etc., drawn, outlined, conceived or formed according to design or design. We would say it's plainly in this provision means planned or intended. So it's intended. The transaction was intended for the purpose of avoiding tax. So we say there's no error of law by the first tier tribunal.
Could I raise with you a point which hasn't been raised, I think, but which troubles me, and if you have an answer to it, that would put my mind at rest. Yeah. The concept of tax avoidance must include avoiding the payment of tax which otherwise would have been payable.
Good, yeah, that's one meaning of it, yes. Right. You can avoid tax that was going to be payable but hasn't yet become...
Yes, that's it. Yeah. Now, if it's accepted as a fact that the purpose which the shareholders had in mind was to enable a business to survive and prosper, which otherwise would have gone under, then it might be said that they haven't avoided tax, because if they hadn't transferred the business, the company would not have been profitable and tax would not have been paid. And so it might be said what the revenue are actually seeking here is to recover tax, which if the company had remained in the UK, it would never have been paid.
But that is imposing a counterfactual
Yes.
on whether tax has been avoided, whether there's been tax avoidance, whereas
Yeah.
what you have to look at is the actual circumstances of what happened. Transferring to a non-resident where income does arise and you don't pay tax on it is tax avoidance. You don't look at what the alternatives might have been. I mean, a taxpayer could say, then, okay, I've got this money, I'm transferring it to a non-resident, and income will arise. But if I hadn't done that, I would have invested it in a non-income producing asset. No income would have arisen. Therefore, I'm not avoiding any tax.
Well,
And that cannot be an argument that can be raised by a taxpayer. He cannot say, well, you know, counterfactually, I would have done something else with the asset.
This wasn't
and therefore
a
I didn't.
choice of the taxpayer. This was something imposed on the taxpayer. You could see that there would be a problem if the taxpayer had structured himself in such a way that he wouldn't be paying tax. But the point that my lord is making is, how can you avoid tax if you wouldn't be paying tax?
Well, first of all, to even get this argument off the ground, which I would submit is not a correct argument in principle, you would have to have a finding of fact that the business was going to be completely kaput. And there wasn't such a finding in this case.
No,
they did carry on making bets.
The question is the purpose. So if the purpose was to save the business, then it's implicit in that purpose that you believed that the company was going to cease to be in business unless you moved.
Well, it might not necessarily. You might just think that it's going to become much less profitable unless you move.
Well, it depends how it's put, but.
But exactly the same argument would be open to my putative taxpayer who's got competition from Bahrain and other low tax jurisdictions and companies there, and says, well, if I don't transfer my business abroad, then it's going to disappear.
Yes. Well,
It depends when. It might disappear over a few years. Therefore, there won't be any tax paid eventually. I suppose the problem with that is you have to. How much tax are you talking about? Supposing there's going to be some tax, but not as much as it's going to be paid.
It might be said that the revenue, having effectively driven the betting industry out of the UK, are now trying to levy the same tax they would have received if the industry had stayed here.
A good deal more.
In fact, yes, a good deal more tax.
Well, as I say, the same argument would be raised by someone who said taxes generally are very high, therefore we've been driven out of the UK and we have to make a transfer. Exactly the same arguments would be
Where do you
raised.
draw the line? Reduce profitability if you stay in the UK to reduce taxes.
Yes.
It's just saying it's an existential threat to the company. It's on a spectrum of adverse consequences.
Yes.
as it were. Yeah.
Yeah.
Well, I've raised the point.
I understand. I understand that, but
And can I raise a point which I put to Mr. Baker as well, just to
Yeah.
help me? Going back to the motive defence and the approach to it in Carville on the second limb. So on the second limb, the defence is made out if the transfer was a bona fide commercial transaction and was not designed for the purpose of avoiding liability to taxation. It's inherent in both the first limb and I think the second limb as interpreted in Carville that you can have multiple purposes, one of which is tax avoidance, but others may not be. So
yeah.
if in our case, on proper analysis, we're dealing with what may be a sort of chicken and egg type situation, how do you save the business by avoiding the tax? Why are you avoiding the tax to save the business? You can't have the two things separately, they go together. Why isn't the proper analysis that there are two purposes for the transaction, and because of this coexistence of the two purposes, it's not possible under the second limb to say that the main reason for the transfer was avoiding liability to taxation?
Well, I think we would submit in situations where you're applying that provision, you have to look at the direct purpose, because otherwise you just get into the problems that I've been discussing, which is there could be results of the avoiding of tax or not avoiding of tax, which are commercial in the sense that you'd have more money, your business would survive or whatever. But that you can't balance those up against the direct purpose, which is to avoid the tax. I mean, what this provision is focusing on is your main purpose to avoid tax, not why are you avoiding tax, putting it that way. It's asking why did you effect this transfer? Now, of course, there can be other commercial reasons for effecting the transfer, which are different. Like, for instance, it might be better, Gibraltar might be a more attractive place to locate your business. You might be able to get better employees in Gibraltar than you get here, but none of that's the case here. But there are lots of commercial reasons why you might do it. But to simply say, well, I'm wanting to save tax so that we'll be more profitable and have more money, that's not a direct, if you like, purpose.
You say this isn't really asking you to look for a counterfactual world. What would be that you're not required to look at or entitled to look at what tax would be payable in the counterfactual world where there was no transfer. You just look at what tax is payable or not payable in the
As it happened, yes.
Yeah.
But yes, not quite sure why that can't be part of your purpose. I mean, the purpose isn't asking the tax authorities, in fact, to apply a counterfactual. It's looking at the reason that you engaged in the transaction. So if you think that your business is going to be destroyed by the imposition of a particular tax charge, and that's why you enter into the transaction, I'm just struggling a little bit to see how you put a ring round what counts as a purpose or doesn't count as a purpose in the context of Section 741, where, as I said, I think on both limbs, you can have multiple purposes.
For the transfer, yes.
Yes.
But
we're looking at the purpose of the transfer.
We're looking. Well, I think with respect, my lord, you're looking at the motivation of avoiding tax rather than the purpose of the transfer. If you were permitted to look...
But sorry, I thought both limbs looked at whether the purpose...
It's the purpose of the transfer.
Yes.
Yeah. So I can see that the purpose of the transfer may be avoiding tax, but that seems to be coextensive. Which has the effect of...
When you say has the effect of, it's the same thing as, or might be said to be the same thing as saving the business.
Well,
in this, on the facts as found, as I understand it, really the transactions are only entered into in order to avoid the tax to save the business.
Yes.
How do you disentangle those things and say, well, one's a purpose, the other's not a purpose?
Well, one's the purpose of sorry, one is the motivation for the purpose. The purpose being to avoid tax. The having more cash, being more profitable, is the motivation for avoiding tax. It has to be that, because otherwise, in every case, you would say...
Because otherwise you say...
There is a motivation beyond saving tax. We're not just doing it for fun.
Right.
I'm doing it because I need, as I said, an operation for my daughter, or all sorts of reasons might be put forward as to why you need more money.
But then, I mean, it might be said that you then just apply the two limbs of Section 741, that the fishers in our case could not succeed on the first limb because one of the purposes on this way of looking at it is tax avoidance, even if they had other purposes.
Yeah.
But on the second limb, it has to be shown that their main purpose was to avoid tax. And if they have a mixture of purposes, and it can't be said that the main purpose was to avoid tax.
Well, first of all, the commissioners did, the first tier tribunal did consider this, and they have made a finding about this. I think what you'd have to say that as a matter of law, that was impossible for them to find that this was the main purpose. Because they
also made lots of findings. Yeah, the sort of chicken and egg findings.
Well, they
did it to save the tax because they thought they were going to lose the business.
They decided that wasn't an independent, if you like, a main purpose.
All right.
That's what the FTD decided. But anyway, I think I may have to give Mr. McGurk some time. Unless there are any further questions, I'm sure there are.
Yes, Mr. Guy.
My lords, my lady, I wish to address you on the EU points at something of a gallop by reference to the following 6 topics. First of all, I want to briefly highlight 3 principles that arise where an EU law challenge is brought against a domestic measure, and which principles are worth emphasising insofar as Anne seeks to rely on her nationality as trumping the tax position that would otherwise be dictated by her residence. Second, I want to show why the transactions in this appeal were wholly internal to the UK, such that EU law doesn't apply at all. Third, I'm going to very briefly look at the meaning of restriction in an Article 49 context. I'm going to have to do that by references to the bundle, given the time. Fourth, I'll explain why the alleged restriction the appellants have sought to fashion in paragraphs 120 to 123 of the written case is wrong, and in particular because it's premised on an incorrect comparator. Fifth, I'll say a very few words on Walloon and why it doesn't assist. And sixth, a very few words on the state aid argument. Before turning to those 6 points, I can put my case in a nutshell in this way. It's common ground that Anne, Stephen and Peter were all UK tax resident and were all assessed to tax under TOA on exactly the same basis. However, notwithstanding that residence is the almost universally accepted basis for the imposition of taxation, Anne seeks to rely upon her nationality to contend that EU law operates to prevent the TOA code from applying to her at all, notwithstanding that you would be left with a situation where the most similarly situated comparators, namely Stephen and Peter, would end up being subject to the code, whereas she would not. And we say it's heretical to seek to invoke EU law to reach a conclusion where similarly situated taxpayers are treated so radically differently, and in particular where that result is sought to be achieved on the basis of reliance on nationality rather than residence. So turning to my first topic, it follows from the fact that each member state has fiscal autonomy that each state can determine whether and how to tax a particular economic activity. In that regard, my lords, my lady, the CJAU has made it expressly clear that if a person moves from member state A to member state B, they can't complain if member state B taxes an economic activity that wasn't taxed in member state A, and they can't complain if a tax rate is higher in member state B than member state A. Member state B is never required to adjust its tax system to hold the person exercising their free movement rights harmless in a tax sense. So if Anne moves and establishes in the UK from Ireland, she can't come along and say, well, this is all fine, and yes, the TOA code applies to everybody here, but on the basis that I'm Irish, it can't apply to me. That is the argument that's been put. Now, in relation to Anne, her home state, of course, is Ireland, and as a matter of principle, either there was a TOA code applicable there or there wasn't. If there was a TOA code, she could hardly be heard to complain that there's a TOA code here. And if there wasn't, it's back to the point that she can't exercise her free movement rights and say, I don't want to be subject to the UK TOA code when everybody else is. In fact, just for your note, there was a TOA code contained in the Taxes Consolidation Act 1997. We don't have it because we don't need to, given the points of principle that I've just mentioned. Secondly, the principle of territoriality. Taxation is not based on a taxpayer's nationality at all. Tax liabilities arise pursuant to the principle of territoriality, i.e. on the basis of whether the taxpayer is resident within the territory. Now, the principle of territoriality involves residents of a country being taxed on their worldwide income, whereas non-residents are taxed only on income arising from sources within the country. In either case, the nationality of the taxpayer, resident or non-resident, is irrelevant. And because the TOA code treats the income of a foreign entity over which a UK resident has power to enjoy as income of that resident, the TOA code is entirely consistent with the principle of territoriality. The point my learned friend Mr. Mullen made yesterday, which is found in the transcript at page 144, that it didn't comply with the principle of territoriality was based on an assertion that the income being taxed was that of SJG, and that's not correct. The CJU's recognition of the principle of territoriality and the role of residents is captured in paragraph 32 in Schumacher, and that's volume 3, 1617. Two things follow from this. First of all, if a person's residence quite properly makes them liable to taxation regardless of their nationality, they can't then rely upon their nationality to trump the tax consequences that flow from their residence. And second, insofar as the whole edifice of direct tax liability is based upon residence and the permissibility of differentiating between different categories of taxpayer on the basis of residence, it would be a nonsense at the very same time to treat residence as a suspect criterion or a proxy for discrimination. Yet that is, in fact, what Anne seeks to do by reference to her reliance upon Walloon, which, of course, is not a tax case at all. Finally, and very briefly, the CJU has accepted that residents and non-residents are, generally speaking, not in a comparable situation, such that, generally speaking, they don't have to be treated equally at all. And if that's a proxy for nationals and non-nationals, it's entirely foreseeable that, generally speaking, non-nationals will be treated differently to nationals in a tax context. There are exceptions. Schumacher concerned frontier worker. He lived in Belgium, moved to Germany, was taxed in Germany, but couldn't have his personal circumstances taken into account, being non-resident. He complained that he was no differently situated from a German worker a couple of miles across the border. The court agreed and said, notwithstanding that he was comparing himself with a resident as a non-resident, they were substantively, fundamentally similarly situated and had to be treated equally for tax purposes. And again, Anne, Stephen, and Peter were all UK residents. It wasn't that Anne was a non-resident and Stephen and Peter were residents. And they were, as was required by EU law, treated identically in the assessments raised under the TOA code. Second topic, we're dealing with a wholly internal situation. We say in essence that the transfer from SJA to SJG is wholly internal and therefore EU law doesn't apply. And we see this from the GBGA case, which is volume 3, page 1646. It was the challenge brought by the Gibraltar Gaming and Betting Association to the tax changes made under the Finance Act 2014 on the basis of its alleged incompatibility of the new duties with Article 56 of the treaty. I was going to take you through this. I'm just going to invite the court to read the judgment in its own time. Can I invite you to read paragraph 6 along with the Constitution Order of Gibraltar 2006, and in particular sections 46 and 47, which you'll find volume 4, page 2014 to 2015. 2014 to 2015, my lord.
Thank you.
Short point on 47.1. It's the provision that indicates what powers, executive powers, are reserved to the governor, and the governor is His Majesty's representative on Gibraltar. Tax is not one of them, but external relations is. And as you'll see when you come back to it, section 47.3 of the Constitution is effectively the domestic analogue of Article 3553 in the treaty. Importantly, for our purposes, the challenge was rejected, and you'll see the conclusion in paragraph 43 of the authority. Page 1651, it follows that the provision of services by operators established in Gibraltar to persons established in the UK constitutes under EU law.
So sorry, which is the page you're on?
1651, my lord, paragraph 43 is the conclusion. The key reasons that allow the court to reach that conclusion are at 40, 41 and 42. In relation to 40, the court considered the argument that movements between UK and Gibraltar should be treated as akin to a cross-border movement for the reason that EU law was made applicable to Gibraltar on the one hand and the UK on the other through different treaty provisions, different legal routes. The court rejects that in paragraph 40. And then importantly in paragraph 41 it says in the second place there is no other factor, and I invite you to underline those words, that could justify the conclusion that relations between Gibraltar and the UK may be regarded for the purposes of Article 56 as akin to those between two member states. Now, if the fact that an operator in Gibraltar was a national of Spain or Ireland was sufficient to mean that this was not a wholly internal situation, the court, A, would likely have said so, and B, could not have put paragraph 41 in the terms that it did, because nationality of the operator would be some other factor leading to an alternative conclusion. It's quite clear reading the judgment, and you'll see this when you come back to it, that when assessing as to whether or not there is a cross-border movement or something akin to it, they are looking at physical movements across border. The court was not remotely concerned with the identity or nationality of those engaged in these transactions, which were regarded as irrelevant. And nothing in the reasoned order in our case, which is in the key documents bundle 237, says any differently. And in fact, paragraph 31 of the reasoned order in our case expressly endorses paragraph 41 in GBGA. So we say on that basis that Anne, relying upon her nationality to say, notwithstanding it's a movement from Gibraltar to UK, or transfer from Gibraltar to UK, you should treat it as akin to a cross-border movement, is just wrong. It is not a factor that can be relied upon to convert a wholly internal movement into a cross-border movement. Moreover, the fact that she's previously established in Ireland doesn't make a difference either. I was going to take you to it, but just for your note, the Court of Appeal at paragraph 99 sets out a passage of Advocate General Gielhode in ACT, where he made clear that disparities between national tax systems did not even invoke Article 49 at all. European Union law was not engaged for the purposes of such a complaint. My short point there is that if Anne is not entitled to invoke Article 49 to complain about the TOA code in the UK upon exercising her right of free movement from Ireland to the UK, a fortiori she cannot complain utilising Article 49 about the tax consequences of a movement between UK and Gibraltar.
I didn't want to interrupt Melanie, but we did, as we were asked to have a little word, and I think it was agreed that we would have 35 minutes to reply. Go ahead, yeah. Don't worry. Thank you.
Well, it looks as though we may have to go slightly beyond 4 o'clock, but I don't want to more than we have to, because we also want time to discuss this case later today. Mr. McGurk, if you can deal very briefly, I think all we need to hear you on really is reminding us of what the ECJ said is very helpful. If you can tell us in a sentence or two what your answer is to Walloon, then that would be helpful. And I think after that we could hear Mr. Baker in reply.
Thank you.
Yes. Before turning to Walloon, I just had one remark I wanted to make about the discussion we had with Mr. Mullen yesterday about your example of finance schemes in the UK.
Yes.
And you'll recall that you posited that and asked whether this would engage Article 49.
Testing the argument.
Well, the point is, he said yes, it does. It engages Article 49, but it's okay because it would be saved, as there would be public policy reasons objectively justifying it. But that is not an answer. That would throw the examples my Lord gave, and indeed the tax differences between England and Scotland, into chaos if all of them suddenly had to be objectively justified. On the meaning of restriction, can I just give you a headline point and some references as to why we say a restriction will only be found in a challenge under Article 49 to a domestic taxing statute if there is discrimination?
I think you're just going through what you were planning to go through. Could you? It
was just references, but I can give my Lord a note of the references if that would be easier.
Yes, that would be easier.
Right.
It's difficult to reply to a note that you haven't seen.
I'm just
can
conscious.
Can you just give us bullet points so that we can draw this to an end in the next few minutes?
Yes. A couple of bullet points on why their argument in 120 to 123 is wrong. They choose a new comparator they ignore completely Stephen and Peter as being the correct comparator for purposes of assessing compliance with Article 49. They say the correct comparator is a transfer to a UK company. But given that reliance is being placed on Alan's Irish nationality, they're changing not one variable, i.e. the nationality, but two. They're changing the residence of the comparator company. But choosing that company, of course, gives them the advantage because they're left in the position whereby Anne becomes exempt from the tow code and Stephen and Peter remain liable under it. So the choice of comparator is a clue to the fact that the comparator is wrong because it ends up with unequal treatment. Walloon, my lord, we simply say it is irrelevant. That case wasn't a tax case at all. It was a case where a residence requirement was applied as a precondition to accessing a social care insurance scheme. The function of residence played in such cases is entirely different to the function of residence in tax. As I've explained to you, in the context of tax, residence is an entirely permissible basis to distinguish between taxpayers. It was pernicious and struck down in Walloon precisely because it imposed a restriction on those seeking to access a social benefit. If you applied the logic of Walloon here, you would turn the tax system upside down because you would be turning a perfectly proper basis for comparison and assessment, i.e. residence, into something that was suspect or a proxy for discrimination. So we say fundamentally Walloon should be just discarded here. It cannot be applied in a tax context. In any event, insofar as it sought to be relied upon to fortify their position that internal movements from Gibraltar to the UK may be subject to EU law, it ignores GBGA. GBGA is the answer on that. And very finally on Walloon, Anne cannot analogize herself with either the Belgians who had exercised their right to free movement or the foreign workers who were restricted coming across a border. The short point in relation to each is that EU applied to those two sets of individuals precisely because they were exercising free movement rights cross-border or would be restricted in so doing. That is not the case of Anne in relation to the transfer between Gibraltar and the UK, or the UK and Gibraltar. So Walloon doesn't help on the substance either. I had a final point on the state aid argument. If my Lord's intent for me to sit down, I can sit down. It will take me 30 seconds.
Yes, we'll give you 30 seconds.
It's premised on the fact that Gibraltar is a region of the UK. It is not. CGBGA, paragraph 6 and 35. In any event, the UK Parliament, and you'll see this when you go back to the Constitution Order of 2006, doesn't pass legislation for Gibraltar. Yeah. It's a matter for the Finance Minister and the Gibraltar Parliament what tax legislation is passed in Gibraltar. It was not a reserved matter. Finally, the Azores case simply doesn't help, my learned friends. In that case, the Azores could be gazumped by the central taxing authorities who could change the tax rate applicable in the Azores. But the EU law of state aid has made it absolutely clear that disparate tax rates within a single member state is perfectly acceptable, so long as each regional authority has full financial autonomy, and Gibraltar does for Gibraltar. So the Azores case doesn't help either. That's a whistle-stop tour. Thank you, my Lord.
Thank you, Mr. McGurk. I'm sorry you've been rather rushed, but that's the way life is, I'm afraid.
I accept that.
Mr. Hafsal.
Yes, Mr. Hafsal.
My lords, my lady, I'll be taking the majority of the reply. I've got 9 points, but some of them are very quick. And right at the end, my learned friend Mr. Mullen will have about a minute or two. Mr. Baker won't be saying anything in reply. The first point is, my learned friend Mr. Ewart, he said that in certain circumstances one can rely on existing cases. He gave examples of capital versus income, emoluments, but he said if the legislation has changed, then you can't use the existing case law, such as Vesti. The simple answer on that is there's been two changes, and I see neither of them are relevant, so materially the legislation remained the same. One change was the introduction of subsection 1A. If anything, that actually helps us. Because as I said yesterday, when you read the preamble, you can spell out of that a requirement that the individual be ordinarily resident at the time of transfer. Well, 1A's taken that away. A requirement of the purpose of the transfer being the avoidance of income tax, 1A takes that away as the entry point. But the third thing, or a third thing you can read out of the preamble, is the need for a transfer by the individual. You must be a transferor. That hasn't been taken out by 1A. So at best, or at worst rather for us, 1A is completely neutral. At best, it actually assists our case by taking away two other requirements, but not the one relevant here. So far as the other change is concerned, 744, the introduction of that, well, we say that doesn't alter matters. As a starting point, prior to 744 being introduced, the position under Pratt was, as Mr. Justice Walton held, that you can't have multiple quasi-transferors. So we make a number of points. The first is, as a starting point, 744 was most naturally introduced to deal with the overlap between 740 and 739. It's unlikely to have had any thinking about multiple transferors. But in any event, we say that 744, given that pre its introduction, the position under 739 was, as per Pratt, you can't have multiple transferors, 744, its introduction couldn't extend the scope of what the existing position was under 739. It can't extend the scope of the existing charging provision. And what's more, the fact that it was included in ICTA 1988 from the outset must be a red herring, because it would mean when 744 was introduced into ICTA 1970, it couldn't apply you couldn't have multiple transferors because ex hypothesis it wasn't part of ICTA 1970 from day one, and yet suddenly when you switch over to ICTA 1988, 744 now has that result because it's part of ICTA 1988 from day one. We say that simply can't be right. So neither 744 nor 1A make any difference in material respects. The legislation considered in Majesty is the same as the legislation we're considering here. And therefore the case of Majesty can be taken into account and should be taken into account. The second point to deal with is a shorter one. It's to do with the CFC legislation. And there's two different points to make on that. The first is my learned friend said, well, when you've got a PLC with thousands of shareholders, you don't have to worry about 739 applying because the CFC rules will apply instead and they will take priority. Well, not necessarily, because the CFC rules apply, A, if the foreign company is controlled by the UK company, which it may not be. It could be it could be a foreign-owned company with less shares held than necessary to result in control. It could be any other company. This catches even bona fide commercial transactions, 739. So there's no reason why when a PLC transfers assets to a company abroad that it will necessarily be controlled. And even if it is controlled, remember the CFC rules only apply if the foreign company is in a low tax jurisdiction, which is defined in the legislation. So it's no answer to say, well, whenever there's a PLC, CFC rules will apply. The separate point to do with CFCs, and I think my Lady Rose and my Lord Sales touched on this, is the word subject to 747 4B in the at the start of the preamble don't imply as a matter of necessity that 739 has to apply to transfers by companies. Now, as I said yesterday, we don't have to go that far in our argument to say that it can never catch a transfer by a company. But the short point is, one can't read that as a necessary implication from subject to 747. The only way that would be a necessary implication is in every case where the CFC rules and 739 both apply, there is always a transfer by a company, and then you'd have to say, well, it's a necessary implication. But it's clearly not a simple example. Individual owns a UK company which owns a foreign company which is within the CFC rules. So income of the foreign company is caught by the CFC rules. The UK company is taxed on that. The individual, because he's an indirect owner of the foreign company, he may transfer assets to that foreign company directly. And that would bring 739 into play. So in that simple example where the individual owns a UK company which owns a foreign company, the individual transfers some assets directly to the foreign company. Could be a bona fide commercial sale, that's called. Any transfer of assets by the individual to the foreign company will trigger 739 in principle. Because it's a controlled foreign company, the CFC rules will apply. So that's the type of circumstance where the subject to 747 will kick in, but you don't have a transfer by the UK company. So it's not implicit in those wordings that you have to find that 739 catches transfers by UK companies. The third point, which follows on from this in one sense, or at least the PLC type example, it follows on from that is, well, what is the principle? And it appeared to me with respect that my learned friend on behalf of the revenue was struggling to find where the delineation would be if it's not limited to a single controlling shareholder. And the various things were put forward in concert, acting together. I think one formulation which was discussed by my Lord Reid and Mr. Hewitt was agreement. And I say a number of points, but the only reason one would be trying to come up with some formulation like this is if one's moving away from Pratt. So you're saying you can have multiple transferors. But we say, as a starting point, it would be wrong for the court to impose some sort of test such as agreement or in concert. The reason I say that is one can look at other areas in the legislation where there are tests of control or similar phrases, and they've given rise to case law and debates and so on. It's a very, very complicated topic in other areas. When the legislation doesn't say anything like that here, I mean, on its face it only applies to individuals, one can see that in reality the transferor might be an individual if he's the controlling shareholder. But to go further and say, well, the principle is if they're acting in agreement, but we said when that's not spelled out in the legislation, that would be a step too far. What's more, how would one apply that? Let's say, for example, does that agreement need to be in writing? Or what if, let's say, 60% of the shareholders ultimately vote in favour of a transaction, 30% of them sit down together in advance, they discuss it and say, yes, we're going to vote in favour. There's another shareholder who owns the other 30%, but he doesn't discuss it with the first 30, but he also turns up and votes in favour. Are those 60 in agreement? 30% might be, but what about the extra individual? And how would this all tie in with my learned friend? This was discussed with my Lord Stevens and my learned friend. The example of taking advice from a tax advisor. But how does that fit in? Why does that mean you're in agreement to do something because you've gone to see a tax advisor? We say it would be a nebulous concept, just as these simple examples can show, and therefore it would be wrong for the court to spell something like that out. What's more, it still doesn't answer the other problems. How do you apply the motive defence? Or more to the point, not how do you apply it, but the unfairness of innocent transferors being caught if you can have multiple transferors being liable. And the other problem is, as I say, 744, if it doesn't, the problems I've already discussed as to why 744 doesn't mandate multiple transferors. It's worth noting two other points on how broad this would go under the revenues case. My learned friend Mr. Hewitt said, well, the aim of the legislation is to discourage transfers abroad. I mean, that's quite a phenomenal suggestion. This legislation can cover bona fide commercial transactions, and to say that it should have no clear delineation because it's designed to discourage people from transferring assets abroad, even in commercial contexts, is quite startling. And in any event, as my Lord Reid said, people must be taxed according to the law. It can't be left in some unclear state just to scare people. Equally, my learned friend had to go so far as to say, well, if you had a director with no shareholding in the UK company, he said prima facie he won't be caught because he probably won't have a power to enjoy of the foreign company. But if he does have a power to enjoy in the foreign company, say he's a shareholder in the foreign company, Mr. Hewitt said he would be caught. But that's bizarre. You've got the asset is owned by a company in the UK. You've got a director with no sort of interest in that asset because he's not a shareholder in the UK company. How on earth can he be a transferor? It beggars belief, to be frank. But when one takes my learned friend's arguments through, and these were some of the points he then had to concede to an argument, it really does become quite extreme. My fourth point is, just to be clear, on Vesti, my learned friend said that Lord Wilberforce, who's the majority in the sense that Lord Salmon and Lord Keith agreed with him, didn't rely on the wording in the preamble in coming up with his natural interpretation. For your note, that's wrong. Page 1442H says, having particular regard to the preamble, and then he set out the two interpretations. So those two interpretations were very much based on the preamble. What's more, it wasn't just Viscount Dilhorn, who was at page 1451 A to B, that expressly set out the words of the preamble when discussing what such an individual means. So did Lord Edmund Davies, that was at 1464B, and so did Lord Keith, 1465G to H. So actually, on any view, all five of the law lords took into account the wording of the preamble. And actually, just for your note, in Congreve at page 1263, one can also see it with Mr. Justice Wrottesley really zeroing in on those words, by means of transfers of assets abroad. Those were the key words.
Could you give me the page number? I'm sorry.
1263, my lord.
Thank you.
In Congreve. Tied in with this on Vesti, this is my fifth point. My learned friend said, in Vesti, the only factor relied upon was the absence of apportionment machinery. I say that's wrong. There was the linguistic point on the preamble, which I've just mentioned, but also let's not forget the spousal extension. That was also a factor relied on by three of their law lords. And the point is this. The law lords in Vesti said the spousal extension only makes sense if the section is limited to transferors. My learned friend says no, even if it applied, as it did in Congreve, to non-transferors, the spousal extension is still relevant because of the power to enjoy. Prima facie, you don't expect that, because if you're not limited to transferors and you're under Congreve, well, anybody with the power to enjoy can be liable. You don't prima facie need to attribute one person's power to enjoy to another. My learned friend says, well, you might need to, because what if the person without the power to enjoy is UK resident and the person with the power to enjoy is foreign resident, or non-resident, non-UK resident? But as I explained yesterday, when you work that through, there's actually no tax avoidance at all. My learned friend said, this is the classic case of avoidance. Your husband is non-resident and you transfer your assets to a foreign company. That's archetypal tax avoidance. The wife could have transferred them directly to the husband in that example without any tax charge. So how on earth is it avoidance to transfer them to the company? That's if it's a foreign source asset. If it was a UK source asset, once again, no tax avoidance, because the foreign company will be liable on it. It's a UK source asset, so there's no avoidance at all. So the point there is that there were lots of factors in Vesti, and there's no answer to any of them, I say, including the spousal extension. My sixth point is, my learned friend said, well, on the Fishers case, if you're a 55% shareholder and you are the sole person who can be the transferor, you're taxed on 100% of the income. And he said that yesterday I responded saying, well, that won't be the case because Section 740 will apply to the minority shareholder. And Mr. Hewitt said, well, that won't always be the case. The point is, with respect, I didn't say that it necessarily would apply to the minority shareholder. I said it may apply to the minority shareholder, 740. It is possible that the 55% shareholder who procures the transfer will be liable on 100% of the income. But that just goes to show that 744 isn't the panacea that it's put forward as. But what's more, and my learned friend overlooks this, is the same point can arise on their case, and that's why it doesn't go anywhere. Let's assume you had a 60% shareholder who votes in favour, you've got a 40% shareholder who votes against. Now, unless my learned friend is saying, well, both of them are transferors, even the one who votes against, it's also the case on the revenues analysis that in that example there would be one transferor, the 60%, there would be only one person who can be taken into account within the wording of 744, and so it would be taxed on 100%. The same point applies to both. It doesn't undermine ours. It's a common point. My seventh point is a short one following on from this. It said that if liability is limited to a single transferor, well, then you can easily avoid the legislation. But as I was at pains to stress yesterday, you're not avoiding the legislation. 740 is sitting there and will tax you on benefits. You're not suddenly getting away with tax avoidance if that's what's happened. My 8th point is it said, well, it must be possible to have multiple transferors, because in Majesty it is said there were joint transferors, and it said there can be other examples such as a painting and so on. And my answer is to that, it's the same with Majesty or the painting example. For your note in Majesty, you can see at 1434C, there were multiple individuals transferring valuable properties, it's described as. And the point is this, whether it's properties of whatever nature or it's a painting, my answer is that you must be transferring your own individual interest in it, and there are multiple, so although there's, in loose terms, multiple transferors, that's because there are multiple transfers. So each of those transferors is transferring his or her own interest in the assets. That's different to a company position, because the company has transferred the asset. The shareholders don't actually own that asset, so you would be effectively...
Isn't the difference rather that you can't transfer the painting unless everybody who owns the painting agrees to it being transferred?
Well, that's likely to be the case, quite right, my lady. But also following on from that, let's say there's two owners. They will each have transferred they will have disposed of or transferred their 50% interest, and the reason that's relevant is because this is all said in the context of the motive defence. Let me put it the other way around. It's the problem with the motive defence would still apply. If you could say there's two transferors of one painting and they've both transferred the same asset, which is what my learned friend says. He says there's two transferors of one asset, and that proves you can have multiple transferors. The same problems which I've been identifying with multiple quasi-transferors, or which Mr. Justice Walton identified in Pratt, would apply in that example. If you've got two owners of a painting and they transfer it, one of them is doing it for tax avoidance purposes, the other isn't. If they are both multiple transferors of the same asset, the motive defence applies once, because there's a single transfer. And if one takes the view that the predominant purpose was tax avoidance, or let's say there were three of them, two of them have a tax avoidance purpose, one doesn't, so you say overall the purpose of that transfer was tax avoidance, the one individual who didn't have a tax avoidance purpose would still be caught. Where I think this was what my Lord Sales was alluding to, which is if my learned friend is right that with a painting or land or shares, you say that there are multiple transferors of one asset, the very same asset, how would you deal with that? There would all be multiple, essentially the problems which existed in Majesty, and equally problems which identified in Pratt by Mr. Justice Walton would apply. But if in those examples, a painting, a land, shares, you say, no, they're each transferring their own interests, then let's say there's three of them, the painting is transferred, each one has transferred a 1/3 beneficial interest. Because there are three transfers, in relation to each of those transfers, you apply the motive defence by reference to the individual who owns that 1/3 interest. The two who had a tax avoidance purpose would fail the motive defence. The one who was innocent wouldn't. So I say when you have multiple transferors of a single asset, it's slightly misleading. They're not actually multiple transferors of the same asset. They are transferors of their separate interests. And so there's no difficulty. So you can't take that example of a number of people selling a painting or shares or land and say, well, you can have multiple transferors and therefore you can have multiple quasi-transferors. The logic doesn't hold. And so in short, we say that you can't have multiple quasi-transferors for the various reasons that I've been discussing yesterday and earlier today in my reply. Motive defence, 744 and so on, and difficulties in drawing the line. And then my 9th and final point, which ties in with this, is that in relation to the difficulties on the motive defence, which we say arise if you can have multiple transferors, my learned friend says, well, you can work out the purpose of a transfer when it's carried out by a company. We're not denying that. That's not answering our point. Our point is this is a penal section with far-reaching consequences, And if the overall purpose is, let's say, because of 2 out of 3 individuals and their purpose was tax avoidance, the overall purpose is taken to be tax avoidance, the innocent person will get caught. And that's the problem, and there's seemingly no answer to that. My learned friend came up with 2 answers today, which I'll address, and then this is the end of my reply. One point he said was, well, the motive defence applies by reference to the purpose of the transfer and associated operations. So he said the fact that you're bringing in associated operations means it could be a tax avoidance purpose by the person who's doing the associated operation. So, although he didn't quite flesh this out, I assume what he meant to say, my learned friend, was you could have a circumstance where the motive defence is failed, even though you have an innocent transferor, because the associated operation had a tax avoidance purpose. Now, with respect, I said that's entirely fanciful, because if your transferor, I mean, your transferor who's starting off transferring the asset, and he's the person, remember, who has the power to enjoy, or she has the power to enjoy. If that person doesn't have a tax avoidance motive, it seems slightly fanciful to suggest that something subsequent in the chain that is done for his power to enjoy will be done with a tax avoidance motive when he himself didn't have any tax avoidance motive, and that's a highly artificial example. The reason the legislation says transfer or associated operations is because you could have an individual. He does have a tax avoidance motive overall, but the first step, his transfer, isn't done with a tax avoidance motive. Let's say he takes £100 or £1 million, he puts it offshore without any thinking of what he's ultimately going to do with it. He just sort of puts it there. And then 2 years later, he thinks, right, now I can do X, Y, Z with that money to avoid tax. Those would be associated operations, but even though his initial transfer wasn't with a tax avoidance motive, his associated operations are, and so you catch him. But fundamentally, the way the motive defence works, including in that example, is where the transferor has that tax avoidance purpose. And otherwise, it would be completely unfair, bearing in mind its extreme consequences. And the final answer my learned friend sought to give on this point was to say, well, look at 740. If the motive defence applies, it also covers 740. Well, yes, but that's no answer to this point. If the motive defence apply, well, the point is the motive defence must operate in a way where an individual who is innocent, by which I mean doesn't have a tax avoidance purpose, can't be subject to the penal consequences under Section 739. The fact that if the motive defence applies, so 739 doesn't apply, equally 740 doesn't apply, it's 2 ships passing in the night. It's got nothing to do with the problem. 740 itself, as an aside, we must remember, isn't a penal provision. It's a tax on the benefit. And if 741 motive defence applies, fine, you don't have a charge under 740. If the motive defence doesn't apply, you have a tax charge on the benefit, which seems very reasonable. But that's got absolutely nothing to do with the fact, and there's no answer to the fact, that on the revenues case, you can get the penal provisions under 739 on a purely innocent person. And then there is, with respect, no answer to that, and that was a point relied on by Mr. Justice Walton in Pratt. And on that, a final parting thought is, as much has been said about 744, it's also important to keep in mind, in addition to all my other arguments on 744, that it has nothing to do with the motive defence. It doesn't answer this problem. Lord Justice Walton identified a number of problems, and the motive defence being one of them isn't answered by 744. So those are my submissions. Unless I can assist you further, I think Mr. Mullen has a few parting thoughts.
Yes, thank you. Mr. Mullen.
My lady.
My lords, my lady. I just wanted to clarify one point. I won't repeat what I said yesterday. And that just goes to the way in which the issue was characterised as Anne relying on her nationality. Actually, and this goes back to Walloon, the critical point is not nationality. The critical point is that she is exercising her right of establishment. And going back to Walloon, you see that there were 2 different classes of Belgian nationals, one who were exercising their rights and one class who weren't. And in this case, if, for example, Peter had gone off and exercised rights previously, he could have brought himself within the 2nd class of Walloon, and he would be sitting alongside Anne, asserting EU law rights. Of course, he didn't, and therefore his position is wholly internal. Where nationality does perhaps come into it is in relation to what the Court of Justice said in this case on the reference, whenever they looked at what was meant by a wholly internal matter, and they defined that strictly by reference to British nationals, and that is obviously why Peter and Stephen cannot rely on EU law rights. But I think most of the rest of the points I've made yesterday, I won't repeat them, so unless there's anything further.
No, thank you very much, Mr. Mullen. And that, I think, completes your reply.
I have nothing to say further in reply, other than to thank you all very, very much indeed for sitting this afternoon when I know that you'd asked us not to, and for going past 4 o'clock. Thank you.
Well, we're, as ever, very grateful to Council for their assistance. There are a lot of rather important and difficult points here, and it's interesting to see that we're not the first judges at this level to have looked at these provisions. We'll obviously take time to reach a decision and issue a judgment. We'll let you have it as soon as we can. Thank you all very much.